of the more fascinating parts of our collection. It's finding records of the higher courts, which includes the Supreme Court, the Court of Quarter Sessions, and district courts. In the spirit of reconciliation, New South Wales State Archives acknowledges the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respects to the elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Now, one of the interesting things about family history is that the more times you get onto the radar of records, the more things you can find. So when it comes to people in your background, you want some of them to have done the wrong thing because there's a lot of records on courts. Now, the second thing is if they're going to be doing something bad, you want it to be very, very bad because the higher courts have a huge survivability rate and you can find them quite often. Now, I'll show you that through today's webinar. Now, we're going to start with some basic definitions. Don't worry, it's going to be legal terms light, but all of them have some usefulness in the research you're going to do in this subject. Common law is the common law division, archivally, deals with civil, criminal, and administrative law matters. If you look in the legal community, common law is based upon previous court precedents. So if you're a watcher of court programs on TV, you would understand that they do work on precedents. That's been quite a part of our legal system for a very, very long time. Criminal jurisdiction is an archival term for the courts of criminal jurisdiction, so any court that's dealing with crime. And when it comes to the higher courts, it's dealing with the most serious matters, including murder and treason. Civil jurisdiction in higher courts refers to non-criminal law. Higher courts hear the largest claims. Equity is something I probably should spend some time explaining, but the gist of it is it's a court of fairness, so that if the lower court's remedies were not adequate, it can be referred to the equity court for final ruling. Now, if you're, from your point of view for the rest of the webinar, this is the information that you will always need when you're doing this kind of research, because this is how the records are consistently organized. They're organized by jurisdiction. So you're looking for little clues like, was it in the Supreme Court? Was it the Court of Sessions? Was it district court? Was it local court? That is a question that you need to be able to answer. It's always the first question I ask when I'm talking to someone on the phone. You also need any dates that you know something happened, because the records are listed by date, and in general you will find that. And you need to know where the court was heard. So it's no good saying it was in Sydney. We would need to narrow it down to which court in Sydney, because that's how the courts the papers are organised. So they're by court, they're by date, and they're by jurisdiction. But the good news is that is all easily findable in most cases. So we'll go forward now. Ancestry have police gazettes online. If you just put in names, you'll get results, and they will list appearances in court and also people being transferred to prison, and among other things. But they're the parts where they will give us information we can use in our research. Newspapers and police gazettes are also on Trove. The newspapers will also mention these things, and I find when I'm doing court research myself, I get most value out of the newspapers. Newspapers once had a different role than they do now, in the sense that they were, without TV as a competitor, they would often go into much more detail and things that nowadays would not be newsworthy. Our own online indexes are getting better and better all the time, and on the subject of courts, we have a lot of coverage, just as long as you understand not everything is indexed. But this is all part of the webinar I'll show you. So the basic rule, everyone, the basic rule is always work out before you jump into looking for records, who, what, where, and when. And if you can think like that, who, what, where, and when, everything else should just fall into your lap one step at a time. So we're going to break today's webinar down into the jurisdictions. And so criminal will start with first, because it's the most commonly researched, and we'll finish the webinar with civil. Now, criminal jurisdictions, the first thing we should talk about is access. Criminal matters are closed for 75 years. Court of Criminal Appeal case records are closed for 75 years. Court reporting transcriptions open after 30 years unless they're heard in camera, which is Latin for closed proceedings, and they're closed for 75 years when they're in camera. And so in general, I've been looking at court transcriptions for many years, and in camera is extremely unusual, and it will be for cases that were particularly heinous in some way. Now we're going to have a quick overview. One of my objectives of today's webinar, I'm going to go right into the stories and the nitty-gritty and show you some records, but I want to have some slides in the webinar where you can come back at a later time and get the details right. So this is a listing of all the things we have by date. In this early period, we have the Court of Criminal Jurisdiction, 1788 to 1833. It's actually indexed online, makes it very easy to find. Now, the big report in 1823 came in here. The Inspector Big essentially said we need a Supreme Court and we need to establish Court of Session so that to take the law out of the hands of the criminal jurisdiction and then to make a more of a along the lines of the British model. So I won't mention him again, except that 1823 years where the Supreme Court was created. And from there, we have these records. So you can see they're long lines in 3 series. The last one goes off the end of the first 2. So we have good coverage from 1823 through to 1972. Now these are in particular are organised by jurisdiction and date. So you will, and also by location. So that just like I've taught you so far, I'll show you how to find these records. They're actually quite easy because the Supreme Court records have a very, very good survival rate. Now, the Court of Criminal Jurisdiction reigned from 1788 to 1823, and I think you could call it a military court because it was staffed by military and naval officers. They had the authority to try all criminal causes, and the only sentences they could inflict were death or flogging. So when we look back at the convict era and we wonder about how things were organised, this is a really good heads up because this is how it was organised by military tribunal and only 2 punishments. It was abolished in 1824 and replaced by the Supreme Court. The Clerk of the Peace comes up in the earlier records as well. The Clerk of the Peace was an officer of the Court of the Criminal Jurisdiction whose duties were to prepare information on the basis of depositions taken by magistrates and to work out if there's sufficient grounds for prosecution and then also to read the indictments in court. So suffice it to say, we do sometimes in the early period have records under Clerk of the Peace and also under the Supreme Court, and they can be a bit overlapping, but that's not an issue for our research. I'm just letting you know that the Clerk of the Peace exists so that you're aware and can move forward with a bit of confidence. Now, the main record types we're looking for and the payoff when we go through these sorts of records is the first thing is depositions. As I just read out in the Clerk of the Peace section, the depositions are taken before a magistrate and also before the main trial. So they are the pre-trial witnesses, and in general, they will be the witnesses that will be brought forward at trial as well. And if you're to read a large number of depositions, you really do have a sense of what happened at trial. We have court reporting transcripts. Now, they're fantastic. I remember referring someone to court reporting transcripts and they read 50 or 60 pages on their case, which would be verbatim everything that was said in the case. And that's almost drowning in good information, but it can be fantastic for your personal history if you're willing to put in the time. The issue with court reporting is that it's not in every case. So clearly they didn't have enough stenographers to go to every case because they're not all transcribed. So it is a little bit of a potluck option. I'll show you how to look for court reporting at a later stage. Judges' notebooks. Now, judges wrote notes during their trial, and they can be interesting. I think they're a bit of a double-edged sword myself because they can be remarkably difficult to read. Even among difficult to read items, they're difficult to read. And in some cases, they're in shorthand. So it's a mixed bag, judges' notebooks, but some are very easy to read, and so they're well worth looking at if you want to, and you can get a little bit of an idea of what the judge was thinking during the trial. It puts you in the moment, doesn't it? So it can be a useful item for your research. So now we're going to look at a case study. I'm going to bring forward case studies fairly often during the webinar, where I'm going to now stop all the theory and show you how it's done in a practical sense. And I'm going to show you all the major ways in at least once. So this is the Court of Criminal Jurisdiction. You can search in collection search, which is what we call this nice little box below the Harbour Bridge. It searches the collection. It's a good name, isn't it? We're searching for Dennis McDaniel. And there it is. First item, criminal court records. That is the Court of Criminal Jurisdiction right there. Now, I'm not going to click on it this time because I'm going to show you an alternative way to do the same thing because it gives you choice. I'm going to the online indexes. I'm going to go down the page to courts and then look for the Court of Criminal Jurisdiction. There it is, Criminal Court Records 1788 to 1833. Now in here, what the advantage of doing it this way is that you eliminate white noise. You're not going to get results in lots of different places and have to sort through them. They're like, in a sense, pre-sorted. So it's just a style choice. When I'm preparing webinars, I quite often will use indexes online because I find it quicker, particularly if I want to look at a large number of different things in the same index. For someone doing their personal family history, it's just an option. You don't need it. So you can search by name, and as you can see there, I put the name in, and we get a result. It's the same result from collection search. And when we look a little bit closer, it gives us the item's location, which is on reel 703 to 703 in box SZ789 and on page 190, and it's also copied onto COD 449. Now, I chose to show you a COD here, in part because it's the last item that went into my webinar, but also just to show you that they're just as good as the other types of records, but in a different format. So essentially, it's a photocopy of the original record. And as you can see, now we'll concentrate on the original record. We can see it presents information that then gets you into the details of what you want to find out. And in this case, Robert Lowe Esquire, Bringelly, April 9th, 1819. Robert Fells, Constable at the cow pastures, charges Dennis McDaniel with harbouring John Davis, a bushranger, and a runaway servant belonging to Mr. William Cox Sr. And moving through the content quickly, found the bushranger behind the door in an inner room. I apprehended him and gave him over to Martin Brooke, the constable. Now this is in miniature. This really does show you what the depositions can be like. They're very, very hands-on. They're very, I saw with my own eyes and style. They're very, they put you there at the time, in the moment. They convey all the emotions and all the matter-of-fact details. And what I find interesting, only as an observer, is notice the underlining is used extensively through the document. Now, I've seen that many, many times with these sorts of records, so it seems to be something that lawyers do who, when they're trying to get the points straight in their own head for what they're going to bring forward in court. So in essence, they're notes for the trial. That is a common feature. So now we'll move to the Supreme Court era. Now, the Supreme Court era, of course, we all know, is started in 1823. The criminal jurisdiction was closed. It was a military court, so we did need to evolve past that. And now we go to a court arranged by judges and law. Now, Supreme Court, by definition, is any crime that's punishable by death before 1955, which is going to be the worst ones. Murder, wounding with intent to murder, setting fire to a vessel with intent to murder, rape, kindly knowing a girl, breaking and entering and inflicting grievous bodily harm, setting fire to a dwelling house, setting fire to a vessel, and altering a light or signal with intent to endanger a vessel. So it's a charming bunch of people who'll be coming before the Supreme Court. You will see other crimes coming into Supreme Court records, and one of the reasons for that is that things change over time, and you will find that as society changes, so do the laws. So there are subtleties that I can't bring forward in such a big webinar today, but you will notice there are sometimes other matters coming forward, and they would have been punishable by death but at one time. So we'll start first with John Knatchbull, a fascinating man. And this is from Information Other Papers, one of the main series of early Supreme Court records. And we're going to start in collection search because it works, John Knatchbull. And we have several results, all from indexes. Now that is the right person, as you can see on the screen. This search is a very good search because there's not other John Knatchbulls muddying the waters. Now what I'm going to do is go to the right-hand side of the screen, and I'm going to click on the Criminal Court Records Index, 1788-1833, and I bring forward, so this would have started in the criminal jurisdiction era, but then be tried in Supreme Court from what I can tell. It's interesting in that it's an exception in that regard. Notice that we find two different cases of forgery. So we can now call Mr. Knatchbull a recidivist. He's, what's the word? He commits the crime again. We'll look briefly just at the 1832 case. Now this is the justice that is involved in this. Justice Dowling is, this is a promissory note written in his name, James Dowling. and it says, pay Matthew Long £6 10 shillings, signed by James Dowling, but unfortunately, it was actually signed by John Natchbull and he was forging the signature. Now that's going to be important for a future case, so just keep in mind that name, James Dowling, and this matter of a promissory note in 1832. Sentenced to 7 years, commuted from death. So it was forgery was a capital offence at that time, which is an interesting thing that wouldn't be the case now. Or even later on in the 1950s, I think, either. John Natchbull in 1844. Now, we've now gone forward 12 years, and Mr. Natchbull, well, we've already established he's a recidivist, and let's see what happens in 1844. Now, another way to find these sorts of records and to find all the jurisdiction, date, and so forth that you will need to do research, Trove is a wonderful resource. It's the part that we want to look at is the newspapers. And they put it in a nice little list there now, so you can target exactly what you want to search. And in the newspaper database, I just put the name of the man and the year I'm interested in. As a matter of fact, there is a lot of activity between the two dates, but for the sake of today's webinar, I can't go into those matters. And we get a lot of information about Mr. Natchbull. He is fascinating. But this is the one I'm interested in, and I'll show you why. It says Supreme Criminal Court in the first line, so immediately my eyes are drawn to that. It gives a date, Thursday, February 1. So we now know where and when. And notice who it's before. Have a good look at that. Before Sir James Dowling. So he's now going to be tried before the man he tried to forge 12 years earlier. I hope he hasn't got a good memory. On the other hand, what are the odds of that? So once we go into the newspaper article, now all these sorts of newspaper articles, in my view, are very, very good reads, and they're well worth it. It's pre-TV, so they go into all the details like a documentary. But you and I, if we're going to go into Supreme Court records, we want to know the who, what, why, when, where. So it usually is up the top. It sometimes can be further down. On trial for murder in front of Justice Dowling, 1st of February, 1844, Supreme Criminal Court. So now we know the who, where, when, and we don't know the why. But if we read the article, it'll go into the details, which include Mr. Natchbull was going to get married in 1844, and he wanted to have some money for the wedding. So he tried to break into a store. Someone objected, and he murdered the woman who objected. So not a nice ending and not a nice story either. The term banco is just something that you will learn as you were studying these sorts of matters. It means having more than one presiding judge. It's a legal term. So now we know the basics. We know what we need to know. It's murder. I didn't put that on the description. I should have. It's that's the what. We know John Natchbull before Justice Dowling. You know, it's the 1st of February 1844, and it's in the Supreme Criminal Court, Sydney. So now I'm going to take you to one of our item listings. We have all the information we need now to see the depositions for this case. This is an item listing that at the moment I would show you in the reading room, or perhaps I would look it up for you as a courtesy. These will be scanned online in the future. So it doesn't hurt us today to talk about it, because you're learning how it's done with your own eyes, and in the future you can do this yourself. So it's just a page. Now on the left-hand side, you can see the box. On the right, in the middle, you can see the year that the records for that are in that box and the locations. So literally, we go down the page for 1844. Oh, there it is. Now we know it was in Sydney. We look down the list and find the location of the court. Now, sometimes when there's a 1 and a 2, it comes down to a judgment call. And I've always gone with, if it's later in the time period, for example, December, it's more likely to be in the second box. It seems to get me through that sort of little dilemma quite successfully. In this case, it is in the second box, and this is a deposition from that box. Now, this is a fascinating read. It gives you the history of John Natchbull, which is not all bad. So I thought I'd bring forward one of the good things. He obtained a ticket of leave in 1829 in consideration of his having apprehended 8 runaways. There's a story right there. I'm dying to know how, under the circumstances, he caught those 8 runaways. That's a research project for tomorrow. Now, we now also know, so we've found depositions, and naturally there's a lot more information in one document. For the sake of a long webinar, I'm trying to keep it nice and short in the different examples. But we know that he was heard before Justice Dowling. And here, if we just search in this collection search Justice Dowling or James Dowling or J Dowling, we will find this, notebooks for the selected cases of Justice James Dowling. And once we go in, we can see we have 9 volumes. Now, this is a point where we would go to the item listings, and I won't repeat the same lesson, but once I went into the item listings, we went through to the right time frame, the right level of court, and this is what I found. Now, remember, this is the man who he tried to forge 12 years ago. The learned judge, notice that he's speaking in the third person. That's quite normal. In pursuance of the statute 6 and 7 William 4C30, 1836, section 2, immediately pronounced sentence of death upon the prisoner in the same manner as other convictions for other capital offences. What I noticed, do you see there's a little bit of a lesson in common law there? He's using precedents that the other matters have been given the death penalty for the same circumstances. A small aside, Mr. Natchbull is the first person in New South Wales and Australian history to say innocent with mental illness, and it didn't work, unfortunately for him. This is I couldn't resist ending the little section with this lithograph. It's the actual hanging of John Natchbull, very rare and very, very relevant to today's webinar. You'll notice in the background, that's Darlinghurst Court. Did I say court? Excuse me, Darlinghurst Jail. The court is there though, of course. Searching Macquarie University. Now this is an interesting aside that I wanted to show you at one point in my webinar today, because it can be very handy for some people in some research. This is the legal people over at Macquarie University preparing for their own case studies in class, I would imagine. Now, if you go here, you can look at the case index, pick a year, 1844, and it gives you a series of cases from that year. Now, unfortunately, it's not all the cases from that year, but you know, it is what it is. If you can find something here, it can be as useful as what I'm about to show you, which is a full summary of that notebook we just looked at a few minutes ago. It's exactly the same resource, and I know because the item listing is there. It's written down as State Records New South Wales, which is our old description, and yes, source, James Dowling, select cases. They're held here, as we all know, because I showed you there. So now we'll go to a different sort of thing. This is for the sort of person who hasn't been able to find their person in Trove, which is, I haven't come across a matter that difficult in my time, but I'm preparing you for, there's always another way to do the same thing. Now, Supreme Court criminal indictments is useful because it's an index for Supreme Court. It covers 1863 to 1919. And we go into the online indexes, C for courts. Then we go down the page and we're looking for criminal indictments index, 1863 to 1919. There it is. We search the index. Now, just a quick aside for today's webinar being so ambitious in topic, I can't go into side notes as well as I would like. But I always recommend, if you want to know what you're looking at, what's the context, what is this, you just click on that link there. It'll take you through to a very good description. The reason I recommend that is because one of the skills of research isn't just to find information. You need to know the context of that information. Why was that record compiled? What is it? What have I looked at? And so that just shows you that you can always backtrack when you're working through our records. For today, we're going to search the index, and I've chosen to do Joseph Blumenthal. And here we are, we've got results. Joseph Blumenthal, wounding with intent to do grievous bodily harm. Charming lot in Supreme Court records, isn't it? Date of trial 1902, 6 jail delivery, which will affect which box it's in usually. Verdict is not guilty. That's good to know. And I take back what I said before, he was innocent. Judge Pring, which is always useful if we want to go all the way with notebooks. And it tells us that this record is available on Reel 1860. Now, this is an example of a record which it has already gone as far as it can go. We have all the information we need. We now know the where, the what, the why, the when, and the who. And we can go forward looking for the depositions, which is where the really good information is, and possibly go on with the other 2 types. We don't need to look at Reel 1860 at all. So we just move forward through to the item listings. And there it is. November is in that box. And so if I'm in the reading room, I can call that up immediately and then look for Mr. Blumenthal's court papers in there. I won't on only because of length of the webinar, but it's as simple as that. So now we'll look at court reporting, and we're going to look at another person just for just a bit of fun, go somewhere different. Eugenie Fellini, 1920. She was convicted of murder in the Supreme Court. Now the transcripts are a little fiddly to search, so I put an example in here to show you that it's not impossible. It's just a bit harder than when it's organized by name, just a little bit harder because it's got so many moving parts. For example, they're listed by year, they're listed by alphabet, and they're listed by jurisdiction. So that's three things that can make for a long list, but I'll show you what to do. It's not impossible. We know that the case took place in the Supreme Court on the 5th and 6th of October 1920. Now, the way I searched for it is the series is NRS 2713, and I wrote the year 1920. Now, if you look down the list, every single one has the year in the listing. Every single one has the series in the listing. So I now have a list where what I'm looking for will definitely be there. And it's only one page of 53 results, which is, as I said, it is a little fiddly, but you can look down the page and you will find it. And I found it down at item 30, because this matches what I'm looking for. Central Criminal Court, 1920, and A to F, and Fellini is an F. So that book there will have the court transcripts if they were taken in court. And here it is, they were. Now, cases are alphabetically listed in the volumes, and literally you just go through and look for the, I always look for the first page of every section, and then just alphabetically you will find the person at some point. And it gives you a lot of information. For example, there's all the witnesses in appearance order. Up there, we know it's heard before Justice Cullen. That's going to be useful if we want to go all the way and go for notebooks. If it's going to be something such as in camera, you probably really won't get to see it because we'll always check for that, but it's written about there, and or if it might say closed court, and either way, you'd have to get permission to get access. And under the State Records Act, you're perfectly entitled to ask, and the Supreme Court, we can help you with how to get that moving. But the vast majority are not in camera, vast majority, so we'll move forward smoothly. You have all the questions and all the answers in there recorded verbatim. So this is a wonderful resource to get the details. It even tells you what pieces of evidence appeared in court. I would anticipate in most cases they will be available in the court depositions. For notebooks, you need to know the judge's name. So we're now looking for the judge of that Miss Fellini's case. Listed by judge's name, our justice is Justice Cullen. And as you can see, because it's a name, you just put the word Cullen into the collection search, you will come up with this result. And after they looked at item listings, I went through and these are notebooks from Ms. Fellini's case. Now, something to remember with judges' notebooks is it's a little bit like I've just gone and looked into your diary. You're writing it for your own purposes. It's in your own handwriting. You're not necessarily neatening it up for everyone to see. So, but that being the disadvantage of a judge's notebook, it is also the advantage because we're getting to see what the judge was thinking without any filtering. And the only thing that I can't prepare everybody for is that they do vary in terms of ease of use. So some will stick strictly to noting the legal precedents or legaling what they need to take into account, keeping the matter straight. Others are going to be using shorthand. I haven't seen a lot of shorthand, but I do know there are some. So it's going to be hit and miss. But one thing I know about family historians is that you're a brave lot, so I wish you the best of luck. And if we can help, we will, because we're very good at trying to interpret handwriting. But this is among the hardest in terms of that sort of thing. Mind you, the example that's on the page, I rate as good. I've seen much, much worse. Let's move on. Just a little bit of a finish for Ms. Fellini. She was guilty, killed her. Yeah, she ended up murdering the partner. And now we move forward to a different jurisdiction, Court of Sessions. Firstly, access. Court of Sessions are closed, and including District Court, after 1955, and they're open before 1955. But if the matter is concerning children, they're closed for 100 years. That's as a victim or as a perpetrator of crime. So that is something we are always mindful of, and we will always vet things before they go out into the reading room. But you will know whether you need to get permission first by looking at those rules right there. Now, if we're going to have a quick look at the overview, Quarter Sessions records begin with the report of Mr. Big, and District Court started slightly later. And so there's an overlapping. So these are like the mid-level courts, okay? They're above local court, they're below the Supreme Court. So they're going to try the crimes that are just down from that in terms of being heinous. They're going to be the next level down. So they won't be for murder, for example. And the coverage is slightly different in terms of how they're organised. The Quarter Sessions are organised by city, country, and case number. And we do have indexes and registers available. So in the case of Quarter Sessions, every time period does have a slightly different way of entering in, and we can advise you of that. And of course, I'm going to show you in a few minutes. District courts are not organised by indexes to the same level. So if you know someone was tried in a district court, we can go straight to the records and have a look. So by looking up that district court by that jurisdiction. The Quarter Sessions is the intermediate court. It's got greater powers than the local court and not as great as Supreme. And anything not punishable by death could be heard in the Quarter Sessions. It was abolished in 1973, and everything was moved over to what's now the District Court. So let's look at something that's a little bit fun. We need some light relief after all the murders. New Year's Eve riot, 1873. Ah, yes. Now I'm going to go to Trove, and in Trove, what you'll see is the usual thing. We're going to get a lot of information very quickly because of the nature of newspapers throughout time was to give these sorts of details. We know it's called the New Year's Eve riot. We know we have a reason, the why. Now the article actually is always worth reading, and I did read this article. It gives a lot of details, but for the sake of looking for Supreme Court records here at State Archives, I found the information I really wanted down the bottom in the last paragraph. The bench felt that this was a case that could be sent to a higher court. Defendants were committed to take their trial at the next Quarter Sessions in Goulburn on 28th instant. So we now know everything we need to know. We know the names. It's a group of people. 28th of January 1873, and it's going to be heard in Quarter Sessions at Goulburn. So do you see that Trove is really your best friend with this kind of research? I've used it more than the police gazettes, which is interesting because the police gazettes are also very useful. Now, the Criminal Depositions Index mainly covers country areas actually, but something to remember about the nature of New South Wales was that we were predominantly country till well into the 20th century. At some point in the 20th century, we became more urban, and we're all used to that now. So in general, there were more people living in the country than the city throughout this period. So this is the majority. Now, always remember with Quarter Sessions, very few case papers survive. It is one of the most gappy series of records that we have. No reason that I can explain for sure, except that the survivability rate in the actual courts wasn't high for some reason. As a result, this index entry is oftentimes the only record available. This is something that most people need to be told at some point because it does affect your research. Now we're going into the Criminal Depositions Index. We're looking for James Bolton. Oh, there he is. Alleged offence riot, Goulburn, committed at Goulburn. Committal was on that date. We have details. The series is NRS 849. The entry is 3916. We have a case number. Remember how they're organised by case numbers? That's what we need. And it's on reel 2760. But that's this record. Okay, this record is on 2760. And I'm showing it to you for just your own learning experience. There it is. 39160. I now know the name of his associates, which is possibly something that might be interesting to you on this occasion. Alleged offence riot. We've got the date, we've got the location he was committed, the trial and the trial date. So the issue is it doesn't add information to go to reel 2760. So I see it as a reference record. We as archivists, we always tell you where we found things, but the actual reel is not where you're going to find more information. The right question is, can we check if papers have survived? And the answer is, yes, we can check. And the item listing is the way to do it. Now, at the moment, I would show you this item listing in the reading room. It's quite easy, but in future, they are going to be scanned and placed online. So that's something you can just quickly do on the description page on our website when the time comes. Now we're zooming in just to make it a bit easier to see. The papers for 1873, there was a Ryle versus Ryle and Ryle for sheep stealing. There was an Edward Waller's escape, and there's nothing else surviving. So this riot, the papers have not survived the passage of time for some reason, and there's nothing we can do. That is a dead end. It just ended. I'm going to show you some alternatives on the next page, but the papers have not survived. And when it comes to quarter sessions, the vast majority of records have not survived. Now, there are alternative registers. This one covers Sydney. I put the description on the screen. You can have a look at it in detail, perhaps after the webinar if you're interested, because it does give slightly more information than we got on that previous register. And for some people, that would be a really good outcome. We have these registers for the quarter sessions in country. Again, it's not necessarily an easy recommendation on my part. I think it's judgments in the beauty is in the eye of the beholder. So it's up to you if you think it's worth it. My message to you today is that yes, you might find extra information in these indexes and registers, but it'll be the odd information, a little bit more perhaps. So we're going to look now at quarter sessions that has survived the passage of time, and that's Tilly Devine, 1925. You might know of her as being the queen of the underbelly during the Razor Wars. And I'm going straight to the heart of the Razor Wars today. We're going to search by her real name, Matilda Devine, 1925. And we found this item in the Government Gazette notices. When I look in, it turns out it says very, very clear at the top, return of prisoners tried at different circuit courts and courts of quarter sessions. So when we go down to Matilda Devine, and I'll just make it a little bit bigger for you, it gives all the key details, malicious wounding, and on whom committed. It gives the victim, Sydney Thomas Thornton Clark. Now you can access police gazettes on the Trove, and you can also access them in the Ancestry. Now the depositions for the quarter sessions in this time period up to 1931, but we have them going forward from there, is in this series, and it's item listed. So you find just how we did all the other item listing examples. But let's cut to the payoff now. I'm more focusing now on, you can get some fascinating things in the quarter sessions if you're lucky enough to get a result. This is actually, oops, I didn't zoom in, which is my normal way. On that page, you get a little bit of a rap sheet of Matilda Devine in her younger days, I might add, before she was legendary. And she seems like a real charmer. Offensive behavior, indecent language, offensive behavior, assault. Common prostitute, offensive behavior, indecent language, assault. I won't go further except to say, oh, it does say down there that she's living with her husband and he drives a motor car, which they own. This car is not used for hire, but only to drive offender and other prostitutes during their calling as prostitutes. Charming. Now, what's also interesting in this quarter sessions is this. Exhibit number 1. Apologies, the software bounced. Exhibit number 1, 2 pieces of steel, 2 razors. What's interesting is that she was being chased by police, and the police found those razors in the gutter out the front of her house, which would have taken some explaining in the quarter sessions. I wish I was there. So we'll stop that story there because we're going through lots of different sorts of records. District Court is slightly remote by comparison. I'll quickly recap that it's closed after 1955. Matters concerning children are closed for 100 years. Now, quarter sessions, it has indexes and registers. District courts are organised by the actual court, and so they don't really have the coverage of indexes that we would like them to have. But that doesn't mean that we can't go there. You might find, for example, in Trove that something was heard in the Newcastle District Court. You just write into our collection search Newcastle District Court, and we can go straight to that agency. Now, what I do, and what I'm showing you and teaching you to do, is just go down to something like this, SEAL series, SEAL records, and it makes a list of everything we have from that court. Now, what you'll notice if you start playing with this in your own time is that they have the same sorts of records that the Supreme Court and the local courts have. For example, depositions. I'd be looking for depositions. I'd be looking for notebooks, and they won't have the court reporting because it's held by a different office. and you'll find the same sorts of things. They also have things like minute books. Okay, so you'll have a slightly different type of record, all well worthy of looking at if you're looking into this matter in the Newcastle District Court, and we hold them here at Kingswood. They're not available online at this stage. So that gives me the opportunity to stop and to say, well, we've finished our section on criminal matters, and I hope I've been giving you some angles. Don't forget, if you found it a really complicated series of information, the webinar is going to be posted online, and I recommend strongly you have another look. I designed the webinar deliberately so that you would have lots of screens that you could examine with a bit more detail in a second viewing. That way, if I'm going a little bit too quick in teaching the big ideas, you can go back and look at the little details. We're now going to take a look at civil jurisdictions, and they can be fascinating in their own right, and they're always very personal. So let's have a look. The first thing is look at the access conditions. They're open early access, Supreme Court, 5 years after finalisation of the matter, unless there's some sort of confidentiality agreement. And judgments are early access, which means available immediately. So these are actually part of the public record, nearly. 5 years is the longest closure period. Now, the Court of Civil Jurisdiction ran concurrently with the Court of Criminal Jurisdiction, finished a bit earlier, where the Supreme Court of Civil Jurisdiction began in 1814 before 1823. We have indexes for those. The big report created the Supreme Court, and a civil jurisdiction has indexes for plaintiffs, which you can look at in the reading room. Equity jurisdiction has index of plaintiffs in equity suits. I'm going to show you examples of these. They're quite simple to use. And district courts, as I've noted already, are organised by court jurisdiction. So it would be a case of looking through the notebooks and minutes. It's a little bit old school in terms of they're not indexed. Now, another thing to learn about civil matters is that they're different in the way they're organised. Firstly, there's a process. Now, the thing about civil cases is that they don't go through to the guilty or not guilty verdict. They go through until everyone says, we agree. Let's agree to or disagree or whatever it is they choose to do. So not every case goes to judgment. Some do, many don't. And so that means we might have process information and we may have judgment information. What I will say is that judgment information is what you all would like to find, but you can generally find out if something went to judgment somewhere else, like in Trove, and not every case went to judgment. So it's a case of you find the highest level of information that's available. And another thing I thought I would mention now is that modern cases are retained by the court as in question. So they're still creating records along these lines. So to give you an overview of the main record types in civil jurisdiction, we have this new record type called process papers and then process books. Books are a bit more like a register. Process papers are a little bit like a pro forma. I'm going to show you both in action. We have judgment papers, rolls, and books, which is the final outcome of the case. You're going to be seeing some of those, so don't worry about that. Court reporting is very similar to before, and judges' notebooks as well. Now, civil jurisdiction matters are claims for damages for personal injury, breach of contract, professional negligence, possession of land, defamation, and these are dealt with by level. So you can have this at a local level, you can have it at a Supreme Court level. So when we're dealing with Supreme Court and District Court levels, there are higher matters, and so they will be for more money than you would expect in a local court. We're going to be seeing a lot of different series in this section. I'm going to quite responsibly show you them all in terms of slides, but I'll very quickly go through to the payoff, and I want you to start noting that we have indexes. That's where you want to start. So online indexes for Court of Civil Jurisdiction makes this part very, very easy and leads through to case papers, as you can see there. Our first case study is going to be Simeon Lord versus William Barnfield. So we go into Court of Civil Jurisdiction Index. For no particular reason, I probably just went here out of habit. Simeon Lord, ex-convict and businessman. Now I notice, and I just thought I'd have some fun with it at this point, there's 20 pages of cases with Simeon Lord in them. So he's either the worst, most unlucky businessman in history, or he's very litigious. I'll leave that for your assessment. On page 8, I found the case that I'm interested in. This 1811 case, Simeon Lord versus William Barnfield. It gives all the details there, the series and the box. And this is the actual item. Now, it's a good one in that it's simple. The handwriting isn't too bad, and so therefore we can examine it and see what it does. Simeon Lord Esquire of 12 William Barnfield writ for my screen's covered on that spot with the software, but I think it says £8 from memory. 8.8, yes. Sold by the said William to the said William at his request. Defendant appeals by William Fleming, who say he's duly instructed by his defendant to admit the debt. So he's essentially rolled over and said, yes, I owe the money. And the decision of the court gives judgment for plaintiff against the goods on 10th of April 1911, damages £8.8 and costs. So it is very much transactional, I think would be a good word, catch-all word, because at the end of the day, any sort of civil proceedings is going to be for restitution of something. There'll be some sort of a damages and costs. And so this is like a really good model to sense the whole series. I'll show you some more modern ones. How's that sound? We move forward in time, the Court of Civil Jurisdiction comes in. We now have judgment bowls, judgment books, process papers, process books, index to judgment books. Just keep in mind, when you're looking through civil court records, we can help you in the reading room, but just keep in mind that it doesn't always go to judgment. And as a result of that, it sometimes is you have to look through the indexes to process books. The next example we're going to look at is Jemima Jenkins versus Thomas Horton. So there she is, Jemima Jenkins. William Charles Wentworth is her attorney. Interesting choice. Thomas Horton, James defendant. James Thomas Horton. Excuse me, it's Thomas Horton James. And suit or plea of trespass on the case of promises. So this is another case of you owe me money, buddy. So let's see how it goes. Upon a certain promissory note bearing the again, I've got software in front of my example. I have to move it. Bearing date 26th of July 1827, drawn by the said defendant, payable to the said plaintiff. And we have all sorts of judgment book indexes. I just wanted to show you the range. It's not something you need to memorize, just to let you know that we have these indexes and they're available. And unfortunately, a gap at one period, we can normally work around gaps and find another way to move forward. The papers we have are very much continuing on to 1913, and I'm aware that we're now transferring into the archives and cases moving forward from 1913. So that's in the near distant future that it will be extended. We have process paper indexes, indexes of process books, indexes of plaintiffs, index for defendants, leading through to the process books and papers. So we'll have a look at a few of these. The indexes are very simple, as long as they cover the dates you're interested in, which is, as you notice there, is a long period. So this is an example of process books. And always remember, not all processes went the whole distance. Here's the plaintiff, there's the defendant, attorneys. This one seems to have gone a fair distance because it's got dates, appearance, declaration, plea, replication, and discontinued towards the end. So it didn't go through to verdict, from what I can see. They went the whole way, but didn't go the whole, they went a long way, but didn't go the whole way. But that is the nature of process books. That's what you find when you go looking. Now, common law civil jurisdiction, we've got judgments books and judgment rolls, judgment papers as well. And when a case went to judgment, this is what you want to find. Windred versus Windred, 1925. Now, it's got basic details at the top, as you would expect. And down the bottom, this one is to the balance due of money received by defendant on account of the sale of the plaintiff's butchery business at Newtown as per account rendered by defendant £87. The plaintiff's share of profits is fixed by rental agreement between plaintiff and defendant at £6 per week for 4 weeks. So we're getting a little bit into the nitty gritty of what's going on in terms of this business in Newtown being sold. So we'll stop there. We've just given you like an overview of the different types of records and how to get started. It is, although there's lots of different options, it is quite simple. And if you find it confusing anyway, don't worry, just ring us or email us and we'll show you exactly where to start and break it down into what you need to do. And it's very simple once you get going. Now, equity is a fascinating type of series. It's early access, which means available after 5 years of finalization of the matter. It actually comes from medieval, when our common law procedures were being developed, it was medieval in the UK, but it came down as a, well, what happens if the local matters are heard and we don't get justice? What can we do? Well, the answer in the Middle Ages was to appeal to the king, and the king referred it to the chancellor, and so anything heard in the chancellor's court became known as equity. And so in a sense, it comes through to us as like a court where final equity can be decided. It's all going to come down to where there are disagreements over what is the right way to go forward according to the law. And so it's a little bit of, in one sense, it's a higher court than the civil, but it isn't really, it's alongside. Now, the sort of things that come up before equity is fraud, breach of trust, specific in performance, injunctions to prevent injustice, injunctions to native legal rights, interpretations of wills. That one is an interesting one for family historians, because I've seen a lot of people look at probates over the years, but not so many look at equity. So if you ever have the sense that someone disputed the will, that is the kind of thing that goes through to equity. Appointments of receivers, company problems, partnerships, land law matters other than ejectment, and that list is only a taste. If you can just remember the concept that it's about fairness, if it's sort of like, well, what's the fair way to go forward, then it goes to the equity division. Now we have the same sorts of records as before, a few different types covering different periods. So no matter which one I highlight in what I'm saying, another one will suit another person for a different time period. So to show you how it works, I chose one from the modern one in the suit books, and it is a famous matter of Keith Anderson versus Sir Charles Kingsford Smith and Charles Ulm, equity in 1928. Now this is interesting because it was all connected to Charles Kingsford Smith's first flight across the Pacific. Now this is the group. Plaintiff Keith Anderson. Keith was in the group to go do the flight, and in the end he ran out of money, came back to Australia and never managed to rejoin them. And so when they came to international acclaim and to offers of money moving forward, he wanted his share of the profits. So he's gone to equity and saying that the being left out of the profits isn't fair, which is right. Charles Kingsford Smith and Charles Ulm, their attitude was, well, look, we abandoned the first flight for lack of money, and you chose to not join the second flight, and that's the way they're going to defend themselves. Now, the actual papers are, well, we can start here in the suit book, and it's just an index. So we go through to Anderson versus Kingsford Smith. I'll just make it a little bit bigger for you so you can see it. What are we interested in? Case number, and there it is right at the start of the page, number 5633. Bingo, I'm in. Now I'm going to go to that page of the suit book only to finish what I started, but it is literally a list of documents. So it's a bit of a heads up on what I'm hoping to find when I move to the depositions. And the depositions are quite full, so I mentioned they're all there, although I didn't do inventory. So case papers. Charles Kingsford Smith equity case is actually separated from this series, so I think at the court level it was decided it was a famous case and they never quite did something with it. So it's now been registered as a different series with us, but it's an exception. The vast majority will be in those case paper item locations, which we can look at item listings and work out which one covers your case number. And when we go through to the records, I could do a talk on this all day long. It's so interesting, but let's just look at a few key highlights. An injunction was put on the sale of the Southern Cross until this matter was closed, so they couldn't sell it. This is a telegram at the time of the first flight, of the actual flight across the Pacific. You can see the date there. It's from Anderson to Kingsford Smith before the flight, and what he says is, you have best possible machine. If your companion's skill equals your determination, you will succeed. Good luck. Regret failure. Furnish my fare. Ensuring my participation was not first consideration. Expect a little justice and compensation upon your arrival here, Anderson, which is very interesting because he took them to court. And so that one right there is interesting from a point of view of a historian looking at this. We'll look a little further in. For the sake of the webinar being a fairly long talk as it is, I have to settle this pretty quickly myself. So we go through to the outcomes, and that is where the rubber hits the road. It was adjudged that he withdrew from the venture, that the defendants gave the plaintiff the opportunity to join them in the new flight, and that the defendants at no time promised and were never under any liability to provide the plaintiff's fare from Sydney to the United States of America to enable the plaintiff to join the fresh venture. So there seems to be a complete ruling in the favour of Kingsford Smith and Charles Ulm. We have the transcripts. As you can see, it's NRS 2713, and you can find those by putting the year. I would, in this case, write NRS 2713 1928. And I'm not going to highlight it too much in this particular part of my talk because I need to draw the line somewhere, but obviously everything about the case is in the transcript. That should be some fun reading for a historian at some point. Now, what's interesting as a side note is that in 1929, only a few months later, Charles Kingsford Smith went missing in the Australian outback. His plane was flying to England, and over the Kimberley, the engine broke down and he had to land the plane. But guess what Mr. Anderson did? He went out and he looked and he looked and he looked, and in the end, his plane crashed or his engine failed and he died of thirst in the search. Charles Kingsford Smith was found, came back to a bit of scandal. Was it all a publicity stunt, which I think is a bit harsh when the planes were so unreliable? And Mr. Flight Lieutenant Keith Anderson, of course, was a hero. And I just find that a nice finish to our little equity piece because they obviously made peace with each other at the end. So just to move on, we do hold notebooks in the Master of Equity. And so, yes, we can go through to notebooks. I've noticed they're a lot neater than the other ones, but I have to look at more of them to be sure if that's a pattern. I assume it's just a judge who, I noticed that they're not verbatim. They don't seem to be writing it during the case. So that's probably why they're neater. I don't regard them as interesting as the other notebooks, but they are easier to look at. So now we'll come to the conclusion of the webinar because we're coming right up on the hour, and I've used all the extra time I'm going to be allowed. There's two ways to do your revision on, three ways actually, two ways to do revision on today's webinar. I recommend both, different ways to do the same thing. Research A to Z. You go into Research A to Z, you go to C for courts, and you'll notice there are guides on different courts. Now, I didn't put Vice Admiralty Court into today's webinar just for the sake of time, but you can use the same methods that I've taught you today to find things. Court of Criminal Jurisdiction is there. So if you want to know more details, Supreme Court, Court of Sessions. So there are guides on all the key areas that I've gone through today. Which brings me to the end of the webinar. And wish you the best of luck in your research, and above all, have fun.